Hello, everyone. My name is Zach Getrich. I'm a founding member of the Central Illinois Research Collective, also known as CIRC. We had a really great town hall a couple weeks ago, and the link of the town hall will be in the description of this video. Unfortunately, we got a lot more questions than we had time to answer. So we're holding this short Q&A part 2 session to answer the rest of the questions we received. If you do still have questions about the SAFE-D Act or CIRC's official guidance on the Act, you can send those to our email at cisolidarity.research@gmail.com. Before we get started, I'll let everyone introduce themselves. And we have both CIRC and a member of Afro-Soc here as well. So, Kyle, why don't you go ahead and introduce yourself?
Hello, I'm Kyle. I'm a member of the CIRC. And I'm glad to be here and be able to answer some of these questions.
I'm Nicholas. I am a member of CIRC. I'm out of Peoria.
And my name is Sarah. I'm also part of CIRC. Thank you so much for coming to the town hall, and I'm also happy to answer some of the questions that we still have from everyone. And I'll pass it off to Robert.
Hi, I'm Robert Garcia. I'm a member of Afro-Soc, and really encouraged by the list of wonderful questions and looking forward to helping answer them tonight.
All right, let's get started. So, Kyle, I have a couple questions for you about when different parts of HB 360. I have a question for you about when certain parts of HB 3653 go into effect. So, what about the cite and release practices that the law requires?
Yeah, so during the pandemic, they've been already doing cite release. The process itself should be cemented in the coming months and years to come.
Okay, and I think it's supposed to be they're supposed to be officially in place by 2023. Is that correct?
Yes, that should be correct.
Excellent. When I know that the HB 3653 changes some things around electronic monitoring, when do those go into effect?
Those are in effect actually now. It's just a matter of waiting for everyone to implement things on their own time.
Okay. And my final question is, when can municipalities start implementing the alt responders, co-responders that are mentioned in the bill?
It can happen as soon as possible. The sooner the better, in my opinion.
Yeah, and does CIRC have a preference for alt responders versus the co-responder model?
Yes, we prefer the alt response model because the co-responder model can do more harm than good, unfortunately.
All right. Well, thank you so much.
Kyle, I have another question for you. I'm still wondering about the concerns about implementation that either this group has or other community members might have.
Yeah, sure. That's completely valid. One of the concerns is the issue of transparency. So we don't have a lot of insight into the inner workings of each police department to easily confirm they have implemented all the provisions. A lot of enforcement would have to be reactive to complaints from the public. A second concern usually is going to be accountability. We don't have exhaustive, proactive audits in place to verify adherence, and we lack a strong set of punishments to be able to enforce adherence at this time.
So is there a recommendation that we as activists and organizers around these issues should do?
We have to keep holding people accountable and to keep making sure that people are transparent with their processes and their decisions.
I completely agree. And just for those that are watching, if you watch our safety town hall, we actually do give a list of basically homework that we expect local legislators to do to help implement this to the best of their ability. And I think we're going to try and go over that at the end of this Q&A. I got a question for Robert. Robert, what kind of enforcement or accountability is there if police officers violate these new regulations?
Sure. Certainly, while the law doesn't give us qualified immunity coming to an end, one of the nice things about this bill is it does have some snippets of accountability sprinkled throughout where it amends other laws in order to add accountability. So this bill actually amends the existing Police and Community Relations Improvement Act so that starting next year on January 1st of 2023, any citizen in the state of Illinois will be able to file an anonymous complaint to the state board. That's the Illinois Law Enforcement Training Standards Board that handles certification and decertification of officers. So this board can pursue decertification based on anonymous complaints if there's evidence. So if anyone has a problem where an officer has lied, they committed perjury in their case, or they saw that that the officer tampered with their body camera, et cetera, as long as there's evidence to support it, this board will actually be able to pursue decertifying that officer so that they can no longer serve as a law enforcement officer in the state of Illinois, which is a great improvement. Additionally, the bill makes law enforcement misconduct a Class 3 felony. So again, another small start towards some sort of accountability for bad officers. So
Yeah,
if
that seems like almost common sense, right? That
right.
that if you break the law, that there might be a punishment for it, right?
Exactly. I mean, if I commit perjury, if I lie under court, under oath, I mean, I'm held accountable. If these folks are law enforcement officers, I mean, certainly, asking them not to commit perjury is pretty, common sense. It's not asking for a lot, but now it's actually codified in law thanks to this bill. So now it's a Class 3 Class 3 felony, if they commit this kind of misconduct. So it's a small step forward, but it's very specific to certain crimes they have to commit. So it isn't ending qualified community, but there are certain things now that they can be, with evidence, can be held accountable for. So if they withhold facts, they misrepresent the truth, etc., not only can they be decertified, they can actually face criminal charges for law enforcement misconduct, which is the first, which is great. It's a small step forward. The other thing that's important is that the Criminal Code of 2012 is being amended with this bill so that this crime is added there as a felony. So it's updating the criminal code to say cops can also be guilty of these crimes, and it has a specific list of misdemeanors that it adds to the criminal code in addition to that felony. And then the last thing it does a lot of other things, but the last thing I'll mention is that it also requires automatic termination if an active officer is convicted of they themselves committing a felony crime, and again, an itemized short list of some misdemeanors. So if I commit a felony and I'm a cop, they're saying I'm not fit to be a cop anymore, and I have to automatically be terminated. I don't, it's just an automatic. If I commit a felony, something else, it wasn't even on the job, but if I'm a felony criminal and I'm convicted, I can no longer be an officer. So again, it doesn't approach ending qualified immunity, which is the ultimate goal, but this bill certainly provides us with a modicum of accountability. So it's a good start.
Thank you so much for that, Robert. And I just wanted to add that like the Illinois Law Enforcement Training Standards Board, ILETSB, has existed for a while. In fact, Bloomington's own Tim Gleason is actually on that board. But prior to this law, it was incredibly difficult to decertify officers. You basically had to be convicted of a felony. But the Safety Act actually dramatically lowers that threshold, so that even if you're not charged with a crime, but if there's sufficient evidence that you would have been, you can still be decertified. And the reason that's just so important is because we know that local states attorneys and police officers, they're colleagues, they work together, they depend on each other. And so oftentimes states attorneys, or at least local states attorneys, are very reluctant to hold police officers accountable. So that's another major improvement that we've seen with this act.
Zach, would you be able to also describe the body cam provisions of the law?
Yes, I can. And I'm specifically, so this has changed since the Safety Act was passed. There was a trailer bill called HB 3443 that is now into law. So I'm specifically just going to go over that because that's what the current law is. I'm going to go ahead and bring this up. All right, so this is what HB 3443, which alters the Safety Act, says with regards to new body cam policies. It says the recording officer or his or her supervisor may not redact, label, duplicate, or otherwise alter the recording officer's camera recordings. Except as otherwise provided in this section, the recording officer and his or her supervisor may access and review recordings prior to completing incident reports or other documentation, provided that the supervisor discloses that fact in the report or documentation. But there are some exceptions to this. So a law enforcement officer shall not have access to or review his or her body-worn camera recordings or of another officer prior to completing incident reports when the officer is involved in or is a witness to an officer involved shooting, use of deadly force incident, use of force incident resulting in like great bodily harm, like you got to take someone to the hospital. And they also cannot review it if they're ordered to write a report in response to or during the investigation of a misconduct complaint against the officer. So those are the main changes that have occurred with the body cam laws. I know that there was a lot of confusion about it. So police officers will be able to review because it's helpful for police officers to be able to review the body cams in order for them to write accurate police reports. And unfortunately, a lot of times police don't write accurate police reports, but unfortunately, a lot of times it's because they're doing it on purpose. But there are very specific cases where they're not able to do that because there's a perceived conflict of interest. So, Nick, I have a question for you. There's a lot of people that are complaining that the Safety Act is leading to a rise in crime across the state. What would be your response to that statement?
Yeah. So, when people argue this law is creating a rise in crime, they're trying to say this is the cause of the increase in crime. So to answer the question, when do we see increases in crime? When you have economic insecurity, people turn to crime to survive. We saw this back in 2008 during the economic downturn as well, where crime increased as people became more desperate. We currently have a once-in-a-century global pandemic, an economic recession, inflation caused by multinational corporations that are price gouging, and an education system that has been unable to adjust to life under COVID. Those are far more significant variables than this law. I'd also like to point out that crime was already on the rise prior to this bill being signed into law. This rise in crime isn't just in liberal cities, but in cities across the country with conservative elected officials as well. And this law was built carefully off of evidence-based practices for pretrial release. The provisions in this bill either have no effect on rates of crime or actually reduce metrics of criminality. So police make the argument that this law is increasing crime, and they're drawing the wrong conclusions about the cause of that increase. If anything, we should expect to see that this law will actually help increase safety of communities by not increasing the economic burden on families and individuals under the eye of our judicial system.
Sarah, I actually have a question for you. With HB 3653, what has changed with the officer complaint policy?
Yeah, so one significant change is that the police complaints are no longer destroyed after 3 years, and that was the case prior to this bill. Now they will have to be maintained indefinitely. If there's a need to revisit the complaints for any reason, maybe someone who makes a complaint would like to revisit their complaint or see that it has been logged and they're no longer able to destroy those. Individuals filing complaints also do not need to notarize those complaints. So that makes the system more accessible. So people don't have to go through the additional step of finding a notary prior to submitting their complaint. That also means that evidence of any police mishandling cited in the complaints will be maintained. And then just one other point too, the public can request information about the complaints outside of the specific names within the complaints through the FOIA process if they're seeking information within them.
And just to be clear, FOIA stands for Freedom of Information Act request.
Yes.
One other thing that I wanted to add is that I did check the Bloomington Police Department's website. and they still have it up on their website that you have to get your complaints notarized. So hopefully we can get a hold of them and tell them that times have changed.
Yeah, and that is in effect now.
Yes.
All right, so now I have a question for you, Zach. So what about Illinois police leaving the profession? Like, what does that mean?
We've heard a lot of complaints that because of this law, police are leaving the state en masse, right? We've heard a lot of sheriffs and police departments saying that they're having a lot of trouble recruiting new officers. If police decide to leave their profession because of this legislation, obviously we cannot stop them from doing so. The point of this legislation is to aid in public safety, not to erode it. However, I honestly think the biggest blame for officers leaving is probably the police unions themselves. I mean, they've propagated so much blatantly false information in an effort to scare people that they've convinced some police that you can't arrest people anymore, or there's a duty to retreat, or whatever other claim that they make that's just clearly not in the law. And instead of being honest with their members, I believe police unions have largely deceived most officers. If that is causing officers to leave the state, that will ultimately backfire and hurt the local and state unions because they'll be receiving less dues. So if people are concerned about Illinois police leaving the profession because of this law, I would make sure that they have the actual correct information on what this law does.
Okay, and I have one last question. Maybe you can answer this one, Zach. Does this law get rid of habitual offender status?
No, it does not. So the habitual offender status, it's each state is a little different. It's similar to like a 3 strikes rule. Like if you commit so many felonies in a period, there's like a sentence enhancement. What the law does change is that the first felony that you committed, because the habitual offender, it's so many felonies, but they can only count the first one once you've achieved the age of 21. And that's when they can start counting those until you eventually would get to a habitual offender status. I'm actually opposed to these kind of sentence enhancements, whether it's 3 strike rules or whatever, because they just mainly serve to dramatically increase incarceration. And I think it's having these types of things in place are one of the reasons that we've seen such an explosion of mass incarceration in the last 30 years. But simple answer, no, this law does not get rid of the habitual offender status.
And before this, if you committed multiple crimes before the age of 21, those were considered like habitual offender.
Yeah, those were counted. I think it went down to 18.
Okay.
But then again, in Illinois, well, a lot of places, but in Illinois, we do have a lot of situations where state's attorneys are charging children, minors, as adults. And that in and of itself is also a really huge problem, just for what we know about brain science when it comes to adolescence, and stuff like that. So
that's a great point.
So those are all the questions that we received and that we wanted to go over just to best educate everyone. Before we end, though, we do want to go over our action steps. And these are steps that local politicians can do to best implement HB 3653, the Safety Act. Those steps include directing their police departments to implement cite and release policies, apply cite and release to as broad a range of crimes as possible with exception to those detainable charges listed in HB 3653, implement and expand cite and release practices now. When it comes to new officer complaint policies, public officials should verify with their police and/or sheriff's department to confirm these policies are in place. With regard to pretrial services, public officials should initiate a hiring freeze of corrections officers and other jail staff, fully fund pretrial services departments, verify that sheriffs are promptly implementing the new phone privileges and pregnant inmate protections as mandated by law. With regards to electronic monitoring, public officials should review what companies the judicial districts are contracting with to provide the surveillance equipment used with electronic monitoring. Review any fees associated with electronic monitoring and do everything in their power to reduce these fees or any debt associated with these fees. When it comes to risk assessment tools, or RATs, public officials should identify what corporations are providing their judicial districts with risk assessment tools, how much is being paid for access to this software, what is the efficacy of their specific brand of tools? How transparent are these companies when it comes to how their RATs work? Thank you to everyone that was a part of our Safety Act Town Hall. And thank you to all of our presenters. The Central Illinois Research Collective is a group that focuses on transparency and accountability in local government and educating the working class on legislation that will benefit. If you'd like to become involved in our work, there is a link in the description that you can fill out. Thank you again to everyone on behalf of CIRC Solidarity.